Picture a 9-ton generator truck parked on a narrow residential street. It's 26 feet long, 9 feet wide, and it's humming at 52 decibels day and night. There's a placard on the dashboard that says, "Medical Support Vehicle, Do Not Tow." It's connected by cable to a townhouse where a woman with ALS is on a ventilator that she will die without. And it's parked directly in front of the only road the HOA president uses to get to her house. Why is the truck there? Because 2 weeks earlier, that same HOA president walked into the utility room and shut off the power to the ventilator at 11:40 at night, over a $375 bill. She knew the ventilator was there. She'd been told, in writing, with medical documentation. She did it anyway. And now, every time she squeezes her silver Lexus past that generator truck, she gets to remember what she did. Subscribe now, because this is the HOA story that ends with a felony. My name's Marcus Reeves. I'm 39. I'm a critical care nurse at Wake County Medical Center in Raleigh, North Carolina. I've spent 14 years working in intensive care units, intubating patients, managing ventilator settings, monitoring oxygen saturation levels at 3 in the morning, while the rest of the world sleeps. I know what it sounds like when a life support alarm goes off. I know what it means when a ventilator loses power. And I know exactly how many minutes you have before a patient who can't breathe on their own stops breathing entirely. In 2021, my mother, Lorraine Reeves, was diagnosed with advanced amyotrophic lateral sclerosis, ALS. By early 2023, the disease had progressed to the point where she could no longer breathe independently. She was on a home ventilator 23 hours a day, with a brief window each afternoon where she could tolerate a tracheostomy collar for light breathing on her own. She also used an oxygen concentrator, a suction machine, and a powered hospital bed with alternating pressure mattress to prevent bed sores. Every one of those machines required electricity. Without power, her ventilator stopped. Without the ventilator, she had minutes. I lived in a 2-bedroom townhouse in a community called Bridle Creek Commons, a 112-unit development on the eastern edge of Cary, about 15 minutes from the hospital. I'd bought the unit in 2019. Nothing fancy, just clean, quiet, and close to work. When Mom's condition deteriorated, I converted the living room into a medical suite. Hospital bed, IV pole, ventilator cart, suction setup, battery backup unit. I had the electrical panel upgraded to handle the medical load, and had a licensed electrician install a dedicated 20-amp circuit for the ventilator. I also registered the unit with Duke Energy as a medical priority address, which flagged our account for priority restoration during outages, and required advance notice before any planned service interruptions. I notified the HOA board in writing the month Mom moved in. I provided a letter from her pulmonologist, Dr. Anand Mehta, confirming her diagnosis, her ventilator dependency, and the medical necessity of uninterrupted power. I asked the board to ensure that any maintenance affecting the electrical systems would be communicated to me at least 72 hours in advance. The board secretary at the time, a reasonable man named Phil Dunmore, acknowledged the letter and said he'd flag my unit in the maintenance records. Then, Phil retired from the board, and Denise Grayson took over. Denise Grayson was 51. A former corporate event planner who'd moved into Bridle Creek Commons after her divorce in 2022. She ran for board president in March of 2023 and won with 26 votes out of 112 units. Most people didn't bother to vote. Within a month, she'd restructured the board, replaced the management company, and started issuing violation notices at a rate that made the previous board look like a suggestion box. Fence stain too dark, violation. Trash can visible from the sidewalk after 7 a.m., violation. Doormat not in compliance with the approved color palette, violation. She ran that HOA like a startup with a burn rate and no product, and every homeowner was an underperforming employee. I stayed out of her way. I had a mother to keep alive. I didn't have time for doormat politics, but Denise had time for me. The first notice arrived in June of 2023, a yellow envelope under my door with the HOA logo, a little horse and fence graphic that always struck me as ironic for a community that had neither. The letter informed me that my exterior medical equipment signage was in violation of Section 4.7 of the CC and RS, which prohibited commercial or non-residential signage visible from common areas. The signage, in question, was a 6-inch by 6-inch red and white placard on my front door that read, "Medical equipment in use. Do not interrupt power." I'd put it there on the advice of the fire department, which recommended visible notification for any residents with life support equipment, so that first responders could prioritize appropriately in an emergency. I called the HOA management office and explained. The woman on the phone said she'd note it in the file. A week later, a second notice arrived. Same violation, now with a $50 fine attached. I called again. Different person, same script. "We'll note it in the file." I wrote a letter to the board, hand-delivered, with a copy of the fire department's recommendation, a copy of Mom's medical documentation, and a photograph of the placard showing its modest size and medical purpose. I asked for a variance under Section 12.1 of the CC&Rs, which allowed the board to grant exceptions for health, safety, or accessibility needs. Denise's response came on HOA letterhead 2 weeks later. It was 3 sentences. The first acknowledged receipt of my letter. The second stated that the board had reviewed the request and determined that the signage does not qualify for a variance, as the CC&Rs do not recognize medical necessity as a basis for exterior modifications. The third informed me that the fine had increased to $150 due to continued non-compliance. I read that letter standing in my kitchen while my mother's ventilator hummed in the next room. Medical necessity is not a basis for exterior modifications. That sentence hit me the way a diagnosis hits a patient. Not with shock, but with the cold recognition that the person delivering it has no idea what the words actually mean. I paid the fine. I removed the placard from the front door and mounted it inside, on the wall next to the entryway, visible through the glass storm door, but technically not exterior. It was the kind of compliance that felt like surrender, and I hated every second of it. But that wasn't the end. It was the warm-up. In August, the HOA issued a special landscaping assessment of $375 per unit. The assessment was supposed to fund the replacement of all common area shrubs with drought-resistant native plantings, a project Denise had been championing since her first board meeting. The assessment was approved at a board meeting attended by 4 board members. The CC&Rs required a quorum of 5 for any special assessment exceeding $200. 4 is not 5. But the minutes recorded the vote as approved, and the invoices went out the following week. I received mine on August 15th. Payment was due September 1st. I didn't pay it, not because I was making a stand, but because I was drowning. Mom's condition had worsened over the summer. She'd been hospitalized twice for respiratory infections. The home health aide who helped me during my shifts had quit without notice. I was working 12-hour overnight shifts at the ICU, coming home at 7 in the morning to check Mom's vitals, managing her medication schedule, coordinating with hospice, and sleeping in 90-minute increments on the couch next to her bed. A $375 bill for shrubs I'd never see was not at the top of my priority list. On September 5th, I received a late notice with a $75 penalty. On September 20th, a second late notice with an additional $100 penalty. On October 1st, a final demand letter warning that failure to remit payment in full within 14 days may result in enforcement actions, including, but not limited to, suspension of community privileges, filing of a lien, or restriction of utility access. Restriction of utility access. I read that phrase and felt something cold settle into my chest. I'd seen those words before, in hospital charts, when a facility threatens to discharge a patient who can't pay. The language of bureaucracy when it decides that someone's life is less important than a line item. I should have paid the assessment right then. I should have borrowed the money, skipped a meal, sold something. But I was running on 4 hours of sleep, and my mother had just had a desaturation event that morning that dropped her oxygen to 81% and set off every alarm in the room. And I was so deep inside the machinery of keeping her alive that the HOA's letters felt like noise from another planet. That was my mistake. Not the only one, but the one that gave Denise Grayson the excuse she'd been looking for. October 2nd, 2023. I came home from a shift at 7:15 in the morning. The home health aide, a new one, a woman named Tamara who'd started the week before, met me at the door. She said a woman from the HOA had come by at 9 the previous evening and taped a notice to the storm door. Tamara showed it to me. It was printed on red paper. the HOA's version of a final warning. It stated that my account was delinquent in the amount of $550, the original assessment plus penalties, and that pursuant to Section 8.3 of the CC&RS, the board had authorized suspension of non-essential utility access, effective October 15th, if payment was not received. At the bottom, in bold type, it read, "This notice constitutes your final opportunity to resolve this matter before enforcement action is taken." I called the management office at 8 a.m. sharp. The manager, a woman named Chris Bowman, answered on the third ring. I told her about the notice. I told her about my mother. I told her about the ventilator. I told her that cutting power to my unit would constitute a direct threat to the life of a ventilator-dependent patient, and that I had documented the medical situation with the board in writing. Chris was quiet for a moment. Then she said, "Mr. Reeves, I understand your situation, and I'm sympathetic, but the board has authorized the enforcement, and I don't have the authority to override a board decision. You'd need to take it up with the president directly." I asked for Denise's phone number. Chris said she couldn't give it out, but would forward my message. I asked for an emergency board hearing. Chris said the next scheduled meeting was November 3rd. I told her my mother might not have until November 3rd if they cut the power. Chris said she was sorry and that she'd escalate my concerns. I called Denise directly. I'd gotten her number months ago from a neighbor. She didn't answer. I left a voicemail, calm, professional, clear. I identified myself, explained the medical situation, and asked her to call me back to discuss an arrangement for the outstanding balance. I said I could pay in installments, starting with my next paycheck on October 15th. I asked her not to take any action that could affect my unit's electrical supply. She didn't call back. I sent her an email that afternoon. Same information, same tone. I attached the original medical documentation letter I'd provided to the board, plus a new letter from Dr. Mehta confirming Mom's continued ventilator dependency. I CC'd the management company and every board member whose email I could find. Denise replied the next morning. The email was 2 lines. "Mr. Reeves, your account is delinquent. The board has voted to enforce. Please remit payment in full by October 15th to avoid further action. D. Grayson, President, Bridal Creek Commons, HOA. No acknowledgement of the medical letters. No acknowledgement of the ventilator. No acknowledgement that a human life depended on the electricity she was threatening to cut. Just a payment demand with the warmth of a parking ticket." I called a lawyer that day, a woman named Janice Okafor, who specialized in HOA disputes and disability rights in the Raleigh area. I explained everything. She listened without interrupting, then asked 3 questions. Did I have the medical documentation in writing? Yes. Had I formally notified the board of the medical equipment? Yes. Did the CC&R specifically authorize the board to cut power to individual units? That last question stopped me. I pulled up the CC&Rs on my laptop and searched. Section 8.3 authorized the board to suspend community privileges and restrict access to community amenities for delinquent accounts. It said nothing about cutting electrical power to individual units. The electrical system at Bridal Creek was shared infrastructure. The main panels were in a locked utility room that served clusters of 4 to 6 units each. Cutting power to my unit would require accessing that room and flipping my specific breaker, an action that wasn't suspending community privileges. It was tampering with utility infrastructure. Janice said, "They can't legally do this. The CC&Rs don't authorize it. Your utility account is with Duke Energy, not the HOA, and cutting power to a medically flagged residence creates criminal liability. Send them one more written demand, certified mail, putting them on notice that any interruption of power will be treated as reckless endangerment and that you will pursue all legal remedies." I sent the letter the next day, certified, return receipt requested. It arrived at the management office on October 7th. The green card came back to me, signed by Chris Bowman. Denise never responded. I tried to believe that silence meant she'd back down, that the certified letter had scared her, that even Denise Grayson, with her color-coded violation notices and her drought-resistant shrubs, wouldn't actually cut power to a house with a ventilator patient in it. I was wrong. October 15th came. I worked a day shift that day, 7 to 7, because I couldn't get anyone to cover my overnight. Tamara was with Mom. I called home at noon, at 3, and at 6. Everything was fine. Vitals stable, ventilator running, suction as needed. Mom was watching a nature documentary about hummingbirds. Tamara said she'd been calm all day. I got home at 7:45. Tamara reported an uneventful evening, handed me the medication log, and left. I checked Mom's ventilator settings, adjusted her pillow, cleaned her tracheostomy site, and started her nighttime nebulizer treatment. By 9 o'clock, she was asleep. The ventilator was cycling at its usual rhythm, the soft mechanical breath that had become the heartbeat of our house. I sat on the couch next to her bed, ate leftover rice and chicken, and started filling out an online payment form for the HOA assessment. I'd gotten paid that day. $550 was going to hurt, but I decided to just pay it and fight the legality later. I entered my card number, hit submit. The website timed out. Connection lost. I checked my phone. Wi-Fi was down. I looked at the router in the corner. Dark. No lights. I looked at the ventilator display. It had switched to battery mode. The green AC power indicator was off. The amber battery indicator was on. The power was out. I stood up fast enough to knock over my plate. I checked the kitchen. The stove clock was dark. The refrigerator was silent. I flipped the hall light switch. Nothing. I looked out the window. The townhouses to my left and right had lights on. The street lamps were glowing. It was just us. My ventilator alarm went off. The low priority alert that signals battery operation. I had 45 minutes on full charge. Maybe 50 if I reduced the tidal volume and respiratory rate to minimum safe settings. I'd tested it during our last hurricane prep. 45 minutes. That was the window between my mother breathing and my mother dying. I grabbed my phone and called 911. I identified myself as a critical care nurse with a ventilator-dependent patient who had just lost power. The dispatcher flagged it as a medical priority. She said a unit was being dispatched and asked if I had backup power. I told her I had battery only and estimated 45 minutes. Then I called Tamara. No answer. I called my neighbor Eddie Vasquez, who lived 2 doors down. Eddie picked up on the first ring. I told him what happened and asked him to check the utility room, the locked room in the breezeway between our cluster of townhouses where the electrical panels were. Eddie called back in 3 minutes. The utility room door was open. The padlock had been removed. He said my breaker, the one labeled Unit 7, Reeves, was in the off position. Every other breaker was on. Someone had gone into that room and flipped my breaker, and only my breaker. I told Eddie to flip it back on. He did. The power came back. The ventilator switched from battery to ASC. The alarm cleared. Mom's oxygen saturation, which had dipped to 93%, not critical yet but heading the wrong direction, stabilized at 97 within 2 minutes. The paramedics arrived 12 minutes later. I met them at the door, explained what happened, and asked them to document the incident. The lead paramedic, a guy named Torres, checked Mom's vitals, confirmed she was stable, and wrote up the call as power interruption to ventilator-dependent patient, likely intentional, power restored by neighbor. Torres looked at me and said, "Someone did this on purpose?" I said, "I think the HOA president turned off my breaker because I owe her $375 for shrubs." He stared at me for a long moment. Then he said, "You need to call the police. Tonight." I called the Cary Police Department non-emergency line at 10:15 p.m. An officer arrived at 11. I gave her everything: the HOA notices, the medical documentation, the certified letter, the emails, the timeline. She took notes, photographed the utility room, and documented that the padlock was missing. She said she'd file a report and that a detective would follow up. I didn't sleep that night. I sat next to Mom's bed, watching the ventilator cycle, watching the green AC power light, waiting for it to go amber again. Every sound in the hallway, a door closing, a car starting, footsteps on the concrete, put my heart in my throat. I was a critical care nurse sitting vigil in my own living room, monitoring my own mother, because the president of my homeowners association had decided that an unpaid landscaping bill was worth more than a human life. At 4 in the morning, I looked at Mom's face. She was sleeping peacefully, her chest rising and falling with the ventilator's rhythm. She didn't know what had happened. She didn't know how close it had been. I was grateful for that. I was also furious in a way I had never been furious before. Not hot, cold. The kind of fury that doesn't shout, the kind that builds a case. The police detective assigned to my case was a man named Sergeant Ray Hollins. Mid-50s, thick mustache, the kind of cop who wrote slowly because he wanted to get every word right. He came to my house on October 17th, 2 days after the power was cut. I walked him through everything again, start to finish. Then he told me something I hadn't known. He'd pulled the security camera footage from the Bridal Creek Commons clubhouse, which had a camera covering the parking lot and, partially, the breezeway where the utility room was located. The footage from the night of October 15th showed Denise Grayson's silver Lexus pulling into the parking area at 11:32 p.m. It showed her walking to the utility room carrying a key. It showed her entering the room. She was inside for approximately 3 minutes. Then she walked back to her car and drove away. At 11:40 p.m., 8 minutes after the footage showed Denise leaving the utility room, my ventilator had switched to battery mode. Sergeant Hollins looked at me across my kitchen table and said, "Mr. Reeves, I want you to understand what we're looking at here. This isn't an HOA dispute. A person with documented knowledge that your mother is on life support deliberately cut electrical power to your residence. In North Carolina, that's assault with a deadly weapon by endangerment. It's also potentially attempted involuntary manslaughter if we can establish reckless disregard for the risk to your mother's life." He paused. "And based on your letters, her emails, and the medical documentation you provided to the board, she knew. She knew exactly what was in that room." I sat there for a moment, processing. Not the legal terminology. I'd worked in hospitals long enough to understand the intersection of negligence and criminal law. What I was processing was the confirmation that this wasn't a mistake. It wasn't a maintenance error. It wasn't an overzealous contractor who hit the wrong switch. Denise Grayson had gotten in her car at 11:30 at night, driven to the utility room, unlocked it with a key she shouldn't have had, and turned off the power to a unit she knew had a ventilator-dependent patient in it. She did it 8 days after receiving my certified letter. She did it with my mother's medical records in her files. Sergeant Hollins told me the case was being referred to the district attorney's office. He recommended I secure a restraining order and consult with my attorney about civil remedies. Then he shook my hand and left. That evening, Janice Okafor called me. She'd already heard from the DA's office. She said, "Marcus, we're going to bury her. Not because we want to, because she built the coffin herself." I took 3 days off work, the first extended break I'd taken in 7 months. I used every hour to build the case that would dismantle Denise Grayson and the board that had enabled her. First, I organized every piece of documentation I had. Every HOA notice, every email, every letter, every fine. The original medical notification, with Phil Dunmore's acknowledgement, the fire department's placard recommendation, Dr. Mehta's letters, both the original and the updated one, the certified mail receipts, the management company's responses, the CC&Rs, bookmarked and highlighted at every relevant section, the police report, the paramedics incident log, the security camera timestamps. I put it all into a 3-ring binder, chronologically ordered, with tabs and a table of contents. 14 years of ICU charting had taught me that documentation isn't just record keeping, it's armor. Second, I had Janice draft and file 3 separate legal actions. The first was a temporary restraining order against Denise Grayson personally, prohibiting her from accessing the utility room, contacting me directly, or taking any action affecting my unit's services. The judge granted it the same day on an emergency basis. The second was a civil lawsuit against Denise Grayson individually, the Bridal Creek Commons HOA, and Chris Bowman's management company for reckless endangerment, intentional infliction of emotional distress, violation of the Fair Housing Act's disability protections, and breach of fiduciary duty. The third was a formal complaint to the North Carolina Real Estate Commission, which oversees HOA management companies, alleging that Chris Bowman's company had failed to intervene despite documented knowledge of the medical risk. Third, I addressed the immediate safety problem. I could not rely on the building's electrical infrastructure to keep my mother alive, not after what had happened. I contacted MedPower Solutions, a company that provides emergency generator services for home medical patients. They offered a mobile generator unit, a truck-mounted diesel generator that could be parked outside my unit and hardwired into my electrical panel through an external transfer switch. The cost was $1,800 per month, covered partially by Medicaid's durable medical equipment provisions and partially by a medical emergency fund through Mom's insurance. The generator truck arrived on October 20th. It was not a small vehicle. It was a white Ford F650 with an enclosed utility bed containing a 40-kilowatt diesel generator, a 200-gallon fuel tank, and an automatic transfer switch. The truck was 26 feet long and 9 feet wide. It required a dedicated parking space, which, in the narrow streets of Bridle Creek Commons, meant it took up the entire section of curb directly in front of my townhouse and extended partly into the travel lane. The MedPower technician, a man named Daryl, connected the generator to my panel through a weatherproof cable that ran from the truck's utility bed, across the sidewalk, and into the exterior junction box the electrician had installed months earlier. He tested the system, simulated a power failure, watched the transfer switch engage, confirmed the ventilator and all medical equipment transitioned seamlessly within 4 seconds. He handed me a maintenance schedule, a 24-hour emergency number, and a placard for the truck's dashboard that read, "Medical Support Vehicle. Do not tow, do not obstruct." I looked at the truck from the sidewalk. It was enormous. It hummed with a low, steady diesel throb that was audible from 30 feet away. It was parked directly in front of the entrance to the Bridle Creek Commons main drive, the only road in and out of Denise Grayson's section of the development. Her townhouse was 4 units past mine, at the end of the cul-de-sac. To get to her driveway, she would now have to navigate around a 9-ton generator truck that was keeping my mother alive. Fourth, I contacted every homeowner I could reach in Bridle Creek Commons. Not about the lawsuit. Janice told me not to discuss pending litigation, but about the special assessment. I pulled the board meeting minutes from the management company's website and confirmed what I'd suspected. The assessment vote had been conducted with 4 board members present. The CC and Rs required 5 for any special assessment over $200. The vote was invalid. The assessment was unenforceable. Every homeowner who'd paid had paid a bill the board had no authority to issue. I printed this analysis, attached copies of the relevant CC and R sections and the meeting minutes, and slid it under 47 doors over the course of one evening. At the bottom of each sheet, I wrote, "If you believe this assessment was improperly levied, you have the right to demand a refund and to petition for a special meeting of the membership under Section 11.2 of the CC and RS." Fifth, I called Duke Energy and filed a formal complaint documenting the unauthorized access to my electrical panel and the deliberate power interruption to a medical priority address. Duke Energy's Customer Protection Division confirmed that tampering with electrical infrastructure serving a flagged medical account was a violation of state utility regulations, and that they would be investigating the HOA's access to the utility room. Then, I went back inside, checked Mom's vitals, adjusted her ventilator humidification, and sat beside her bed. Outside, the generator hummed. Inside, the ventilator cycled. 2 machines, breathing in tandem, keeping one woman alive despite every effort to the contrary. The generator truck lasted exactly 14 hours before Denise Grayson declared war on it. At 8:15 the next morning, I found a violation notice taped to the truck's driver's side window. It cited Section 5.2 of the CC and Rs. No commercial vehicles, trailers, boats, or oversized equipment shall be parked on community streets or in designated parking areas for a period exceeding 24 hours. The fine was $200 per day, effective immediately. I peeled the notice off the windshield and brought it inside. Then I called Janice. Janice laughed. Not a mocking laugh, the short, sharp laugh of an attorney who has just been handed a gift. She said, "Marcus, the Fair Housing Act requires HOAs to make reasonable accommodations for residents with disabilities. A generator that keeps a ventilator-dependent patient alive is the textbook definition of a reasonable accommodation. If they try to tow that truck or fine you for it, they're in violation of federal law, and the damages go from 5 figures to 6. She drafted a response that afternoon, a formal, reasonable accommodation request under the FHA and the North Carolina Persons with Disabilities Protection Act. The letter explained Mom's condition, documented the power shutoff, identified the generator as a necessary medical accommodation, and informed the board that any attempt to fine, tow, or restrict the generator would constitute disability discrimination and would be added to the pending civil suit. Denise's response came not as a letter, but as an action. On October 22nd, 2 days after the truck arrived, she called the Cary Police Department and reported an illegally parked commercial vehicle obstructing a public roadway. An officer arrived at noon. I met him outside. The officer looked at the truck, looked at the medical placard on the dashboard, and looked at me. I handed him a copy of the reasonable accommodation request and Dr. Mehta's letter. He read both, nodded, and said, "Sir, as far as I'm concerned, this vehicle is providing a medical service and is legally parked. I'll note this call is unfounded." Denise called again the next day. Different officer, same result. She called a third time on October 24th, this time claiming the truck was creating a noise nuisance that violates the county noise ordinance. A code enforcement officer came out with a decibel meter. The generator registered 52 decibels at the property line, quieter than a normal conversation. The county noise ordinance threshold for residential areas was 60 decibels. The officer logged the complaint as unfounded and left. But Denise wasn't finished. On October 26th, she convened an emergency board meeting, without proper notice, without quorum notification, with only her 3 allied board members present. The single agenda item was removal of unauthorized commercial vehicle from community property. The meeting lasted 20 minutes. The board voted 3-0, with the 5th seat still vacant since Phil Dunmore's departure, to authorize the management company to have the generator truck towed at the owner's expense. Chris Bowman, to her limited credit, called me before scheduling the tow. She said she was uncomfortable with the situation and wanted to give me a heads up. I told her that towing a medical support vehicle from a residence with a ventilator-dependent patient would constitute criminal reckless endangerment under North Carolina law, and that I would have the tow driver arrested on scene. I was not bluffing. I'd already spoken to Sergeant Hollins, who had told me that any attempt to remove the generator, given the documented circumstances, would be treated as a continuation of the October 15th offense. Chris called back an hour later and said the tow had been canceled. She also said, quietly, that she was resigning as the management company's point of contact for Bridle Creek Commons, effective immediately. Meanwhile, the truck sat where it was. 26 feet of diesel-powered medical infrastructure, humming steadily, day and night, keeping my mother alive and forcing Denise Grayson to squeeze her Lexus past it every time she came and went from her townhouse. The road was narrow, standard 2-lane, no shoulder, and the truck reduced it to a single lane at the point where Denise's section of the development connected to the main entrance. She could get through, but not comfortably, not quickly, not without being reminded every single time of what she'd done and why that truck was there. Daryl came by every 3 days to check fuel levels and run diagnostics. Each time, he found a new violation notice on the windshield. He started collecting them in a manila folder. By the end of October, there were 11. I told him to keep them all. Every one was evidence. The homeowners' petition hit the board like a wrecking ball. 34 homeowners, out of 112 units, signed a petition under Section 11.2 of the CC and RS, demanding a special meeting of the full membership to address 3 items: the validity of the landscaping assessment, the conduct of the board president, and the proposed removal of a medical support vehicle from a disabled resident's property. Section 11.2 required signatures from 25% of the membership, 28 units, to compel a special meeting. We had 34. The petition was delivered to the management company on November 1st by hand, with a copy sent to Janice's office and another to the Wake County Register of Deeds, where HOA governing documents are filed. Denise tried to block the meeting. She sent an email to all homeowners claiming the petition was procedurally deficient because it had not been submitted on the approved petition form, a form that did not exist in the CC and Rs or any board-adopted resolution. Janice sent a response letter pointing out that the CC and Rs specified no particular form for membership petitions, and that the board was legally required to schedule the meeting within 30 days of receipt. The meeting was set for November 29th at the Bridle Creek Clubhouse. In the meantime, the legal machinery was grinding forward. The DA's office formally charged Denise Grayson with 1 count of felony assault by endangerment and 1 count of tampering with utility infrastructure. The felony assault charge was based on the deliberate power shutoff to a ventilator-dependent patient with documented prior knowledge of the medical risk. Under North Carolina law, assault doesn't require physical contact. It requires an act that creates a substantial risk of serious bodily harm with reckless disregard for that risk. Turning off a ventilator patient's power at 11:40 at night meets that standard with room to spare. Denise was arrested at her townhouse on November 8th. Sergeant Hollins told me later that she opened the door in a bathrobe and asked what it was about. When he explained the charges, she said, "This is about a delinquent assessment. I was doing my job." He said that was the moment he knew the prosecution wouldn't have trouble establishing intent. She posted bail, $25,000, the same afternoon. Her attorney, a criminal defense lawyer named Martin Bexley from a firm in Durham, immediately filed a motion to dismiss, arguing that the power shutoff was an administrative action within the scope of HOA governance and did not constitute criminal conduct. The motion was denied. The judge wrote in his order that the deliberate interruption of electrical power to life-sustaining medical equipment with documented knowledge of the patient's dependency transcends the bounds of any administrative authority and constitutes conduct for which criminal liability may attach. The local news picked it up the week of her arrest. WRAL ran a piece with the headline, "HO, a president charged with felony after cutting power to ventilator patient." The story included my interview, calm, factual, no embellishment, and a statement from Denise's attorney claiming she was innocent and confident of vindication. The story also included a quote from Dr. Mehta, who said, "Interrupting power to a ventilator-dependent ALS patient, even briefly, creates an immediate risk of respiratory failure and death. There is no circumstance under which this is an acceptable action." The online response was immediate and overwhelming. The story was shared tens of thousands of times. My inbox filled with messages from people across the country who had dealt with similar HOA overreach. People whose medical equipment had been threatened, whose disability accommodations had been denied, whose lives had been treated as line items. A disability rights organization in Charlotte contacted Janice and offered to file an amicus brief if the case went to trial. Denise's allies on the board began to distance themselves. One resigned by email, 3 sentences, no explanation. Another stopped responding to communications entirely. The third posted on the community Facebook group that she had voted in good faith based on the president's representations and had no knowledge that Mr. Reeves's unit had medical equipment. That post was screenshot and added to our evidence file, because she had been CC'd on the email I'd sent with Dr. Mehta's letter attached. By mid-November, Denise Grayson was facing a felony charge, a civil lawsuit, a board recall, and a neighborhood that had turned its back on her. The generator truck sat in front of my house, humming its low diesel note, day and night, like a heartbeat, and my mother slept peacefully through all of it. The special membership meeting on November 29th was the most crowded event Bridal Creek Commons had ever hosted. 61 homeowners showed up, more than half the community. The clubhouse meeting room held about 40 people. The rest stood in the hallway and the foyer with the doors propped open. Janice told me not to speak. She said the homeowners needed to do this themselves. It was their community, their board, their vote. My role was to be present, visible, and silent. So I sat in the second row, with my hands folded and my binder on my lap, and I let the room do the work. Reggie Chen, no relation to the Dave Chen from the other story, just a coincidence of surnames, had organized the petition drive. He was a retired high school principal, 70 years old, wire-rimmed glasses, the kind of man who could silence a room just by standing up slowly. He opened the meeting by reading the petition items aloud, then yielded the floor to homeowner comments. The first speaker was a woman named Anita Reese, who lived in the unit directly above mine. She said she'd been woken by the paramedics on October 15th and had come down to find out what happened. When she learned that the HOA president had cut power to my mother's ventilator, she said she'd been physically ill. She said she'd lived in Bridal Creek for 9 years and had never been ashamed of her community until that night. The second speaker was a man named Paul Okonkwo, who worked in IT and had done the math on the landscaping assessment. He'd reviewed the board minutes, confirmed the lack of quorum, and calculated that the HOA had collected approximately $31,000 from homeowners for an assessment that was never legally authorized. He asked the membership to vote for a full refund. The third speaker was Marcus Webb, who served on the board and had voted for the assessment. He stood at the front of the room, looked at the floor, and said he owed the community an apology. He said Denise had told the board that the assessment vote met quorum requirements and that he had taken her word for it without checking. He said he should have checked. He said he was resigning from the board, effective immediately. Then he sat down. 8 more homeowners spoke. Some were angry, some were emotional. A woman named Claire Dubois, who had a wheelchair-bound son with cerebral palsy, said she'd been fighting the board for 2 years to get a ramp installed at the clubhouse entrance and had been denied every time. She said, if this board can spend $30,000 on shrubs without a legal vote, but can't spend $3,000 on a wheelchair ramp, then this board doesn't represent this community. The room applauded. It was the only time anyone clapped during the entire meeting. Denise was not present. Her attorney had advised her to stay away, and the restraining order complicated her attendance at any community event where I might be present. But her absence was its own kind of statement. The president of Bridal Creek Commons couldn't attend a meeting of her own community because she'd been arrested for nearly killing one of its residents. The membership voted on 3 motions. First, a vote of no confidence in Denise Grayson as board president. The vote was 57-4. She was removed. Second, a motion to rescind the landscaping assessment as improperly levied and to refund all collected payments. The vote was 59-2. Third, a motion to amend the CC&RS to add a provision explicitly prohibiting the board from taking any action that interrupts utility service to any unit, with a specific clause requiring written medical accommodation plans for residents with documented medical equipment needs. The vote was unanimous, 61-0. After the votes, Reggie Chen stood at the front of the room and said something I'll never forget. He said, "A homeowners association exists to protect the people who live here, not the landscaping, not the property values, not the rules, the people. When we forget that, we become the thing we were supposed to protect against." The room was quiet. Then people started leaving. A few stopped by my chair. Some shook my hand. Anita Reese hugged me. Claire Dubois squeezed my arm and said, "Your mama's lucky to have you." Paul Okonkwo handed me a flash drive with a full forensic analysis of the HOA's financial records and said, "You might want to give this to your lawyer." I drove home in the dark. The generator truck was still there, still humming. I parked behind it, went inside, and checked on Mom. She was awake. It was one of her alert evenings, when the disease gave her a few hours of clarity. She couldn't speak anymore, but she could blink, and she could squeeze my hand. I sat beside her bed and held her hand and told her what had happened. Not the legal details, the simple version. I told her that the neighbors had stood up for us, that they'd voted to protect her, that nobody was going to touch the power again. She squeezed my hand twice. That was her signal for good. I squeezed back and sat there until she fell asleep. The criminal case resolved in February of 2024. Denise Grayson's attorney negotiated a plea deal to avoid trial. She pleaded guilty to 1 count of misdemeanor assault, reduced from the felony charge, and 1 count of tampering with utility infrastructure. She received 2 years of probation, 200 hours of community service, a permanent restraining order barring her from serving on any HOA board in North Carolina, and a restitution order of $12,000 covering my emergency medical expenses and the cost of the generator service. The civil case settled 4 months later. The HOA's insurance carrier paid out $185,000, covering the generator costs, legal fees, emotional distress damages, and a structured fund for medical accommodations at Bridal Creek. Denise was personally liable for an additional $42,000, which was garnished from the sale of her townhouse. She moved out of Bridal Creek Commons in April. Nobody threw her a going-away party. The management company, faced with the real estate commission complaint and the forensic financial analysis Paul Okonkwo had assembled, which revealed nearly $11,000 in unauthorized disbursements during Denise's tenure, voluntarily terminated its contract with Bridal Creek. A new management firm was retained by the reconstituted board. The new board was elected in January. Reggie Chen became president. Claire Dubois joined as the accessibility officer, a new position created under the amended CC and Rs. The wheelchair ramp was installed at the clubhouse by March. The generator truck left on December 15th, 2 months after it arrived. Duke Energy had completed its investigation and installed a tamper-proof lockout on the utility room, with medical priority units keyed to a separate, independently secured circuit. The new board also installed a security camera covering the utility room entrance, the one thing that should have been there from the beginning. Mom passed away on June 7th, 2024. Not from a power failure, not from anything Denise Grayson did, from ALS, which takes everything eventually, on its own schedule, with a cruelty no HOA president could match. She died in her bed, in our living room, with the ventilator running and the lights on and me holding her hand. I stayed in Bridal Creek after she passed. I thought about moving. The living room still felt like a hospital room for months, but the neighbors wouldn't let me disappear. Anita brought food. Paul checked in every week. Reggie invited me to board meetings, not because I had anything to contribute, but because he said the community owed me a seat. On a Saturday morning in September, I walked out to the curb where the generator truck had been parked. The asphalt still had faint marks from the outrigger pads. I stood there for a minute, looking at the empty space, thinking about the 45 minutes that had separated my mother's life from Denise Grayson's ego. 45 minutes. That's how long the battery lasted. That's how long it took for a neighbor to answer his phone, walk to the utility room, and flip a switch. That's how long a human life hung in the balance, because one woman decided that $375 was worth more than a breath. I went back inside, made coffee, and sat on the couch where Mom's bed used to be. The house was quiet, no ventilator, no generator, no alarms, just quiet. I drank my coffee, then I went to work.
What haunts me isn't the power shut-off, it's the timing. 11:40 at night, no maintenance crews, no notice, just Denise Grayson alone in the dark, with a key she had no business using, flipping a breaker with a medical tag on it, knowing there was a woman on a ventilator behind the wall. Over $375 for strap. Marcus won because he documented everything, every letter, email, certified mail receipt, every fine. When the power went out and the ventilator alarm screamed, he didn't panic. He called 911, his neighbor, his lawyer, and then built the most anti-case I've ever seen. And with anger, with the same precision he used every night, keeping patients alive in this ICU. The real lesson isn't about HOAs or assessments or the law. It's about what happens when someone in authority stops seeing people and starts seeing life items. Denise didn't see the ring ribs. She didn't see the hospital bed or ventilator. She saw a number that wasn't green, and she decided to fix it, no matter what it cost. That's the danger, not the rules. The moment someone with a little power decides compliance matters more than compassion. That's a landscaping fee matters more than a mother's breath. If you are seeing an authority used to hurt instead of help, drop the story in the comments and subscribe, because next time I'm covering the HOA that during a veterans therapy pool and filled it with concrete overnight. You do not want to miss that.